because I know you have seen it and you have gone through many times. Who prepared this agreement before we go on? From page 51 to page, Your Worship, to page 62.
Yeah, it was prepared by Namcor, Your Worship, because it's on a Namcor letterhead. The first page is a Namcor emblem is there, so it was prepared by Namcor.
Okay. In which department?
The legal department.
The legal department. Yes. Okay. Now, if you go to 1.1, they talk about purchase and sale of assets. What did you buy from Enacon, and what did Enacon sell to Namcor?
We purchased rights, title, and interest into those assets. Yeah, we bought Enacon's rights, title, and interest into those assets. That's what we bought.
Because when you go through all the counts and throughout all the accused person, not just you, they talk about 9 service stations.
Yes. So yeah, I don't know what they're talking about. So it's clear here what it was that we purchased.
Okay.
Just slow down before you.
Thank you, Your Worship.
Just to clarify on the page 51.
Yes, sir.
Testified the agreement was prepared by Namcor. Just want to understand. Prepared by Namcor or was it prepared by Namcor Trade?
Or by Namcor Trading. It was prepared by the lawyers on behalf of Namcor Trading and Distribution.
Not Namcor.
No.
Because you earlier testified prepared by Namcor. That distinction.
Okay. There are not two legal departments. There's one legal department, National Petroleum Corporation of Namibia, Namcor. However, that legal department also serves Namcor Trading and Distribution. So the legal, yeah.
Try to slow down.
Yeah.
Yeah, so agreement, my question is, was it prepared by Namcor or Namcor Trading?
Yeah, it was prepared by Namcor Trading because this is a Namcor Trading agreement. It was prepared by Namcor Trading by the legal department of Namcor. Because it is an agreement between Namcor Petroleum Trading and Distribution and Enacon.
Please, according to Your Worship, let's carry on with the 1.1. Can you read the paragraph after Exhibit B at page 53, Your Worship?
Before the effective date, Enacon shall deliver to Namcor Trading all certificates, ownership documentation, registration documents, asset maintenance records, asset register, as signed by the auditors, warranties, if any, or any other documentation necessary to ensure transfer of ownership of the assets to Namcor Trading.
Okay. Was this clause or parts of this clause, was it complied with by Enacon?
Yes, at least part of the clause was complied with. Obviously, I didn't work with these things directly myself, but before I signed the agreement, I could see the asset register, and I was told that was the proof of ownership that would be required for us to proceed.
Okay, while you are there, Your Worship, I want the witness to go to page 79. of the bundle, Your Worship. Are you there, Mr. Mulunga?
I am there, Your Worship.
Are you aware of that document?
Yes, I am aware of it, Your Worship.
Because I see it, to whom is the document addressed?
It's addressed to myself as the Managing Director of Namcor Petroleum Trading and Distribution Pty Limited.
And the purpose of the document?
It's the Enecon Asset Register for Ministry of Defense and Veterans Affairs petroleum product storage facilities and related installations.
Yes. Then we went through this document, but for the record, you have seen it. This, according to you, this is the document you received about the ownership of the assets.
Yes, Your Worship.
And then you go to the next page. No, before you go there, you can see the author. Who is the author of this document?
Enecon Namibia.
No, the author. The
author.
person who
Oh,
signed.
the author. Ducatus Financial Consultant, CC.
Yes. And they say, can you read the paragraph? Starting with we.
On which page?
79.
Oh, yeah, we confirm that we are the internal accounting firm for Enecon Namibia Pty Limited. We also confirm the correctness of the Enecon Assets Register in respect of Enecon Modva Petroleum Product Storage Facilities and related installations per Annexure A, hereto attached, based on Enecon inventory.
Then you go to Your Worship, page 80. Those are the assets until page 85. You saw that document.
Yes, I did, Your Worship.
And you said this was in compliance with the 1.1, clause 1.1 of the agreement.
Yes, Your Worship.
Now, of course, we know it's not in dispute that after receipt of asset register, Namcor made payment of 35 million to Enacon joint account together with Namcor, correct?
Yeah, I believe they paid the 53 million in total. Yeah, and the 35 million. They paid, I think, the separate amounts. So we discussed it, the 35 million and the 18 million. As was testified yesterday.
Okay. Yeah, that one is not in dispute, Your Worship, because they are paying statement to that effect.
Mm-hmm.
Now, after Namcor paid the 53 million,
Yes.
did you take possession of the subject matter of the sale or the asset you bought? When I say you bought, I mean Namcor.
Yes, Namcor Trading.
Yes, Namcor Trading, correct.
Yeah, obviously, Your Worship, we couldn't physically take possession of the facility. Oh, okay. I mean, you can't physically take possession of the assets because they are in the various bases of the. Okay.
Your Worship, I think I have to.
However,
Sorry, Your Worship, pardon. I think I have to rephrase, not possession, but delivery. The delivery of the assets by the seller to the buyer. Buyer being Namcor, seller being Enacon.
okay. So, Your Worship, you can't take physical delivery of the assets because the assets are built on the facilities or on the various sort of facilities of the Ministry of Defense. So, according to the agreement, the ownership of those assets will change on the effective date.
Just pause.
So according to this specific agreement that we signed, it says clearly under 1.3 that the purchase of the assets, this is on page 54, Your Worship, the purchase of the assets and transfer of ownership of the assets to Namcor Trading shall be effective on the date when the last party signs this agreement. So meaning from the 18th of July 2022, those assets then belong to Namcor. This is what the agreement is saying. So there was no other physical moving of the assets from one point to the other. The assets remain there because they are supposed to serve the purpose to deliver, deliver fuel to the various bases of the Ministry of Defense. So you can't move them. You just transfer ownership and rights as to who can now supply their fuel into those tanks.
Okay. Yes, Your Worship. Now, did you, as per the agreement of March 2022, that session, the exclusive, the supply of fuel,
the fuel supply agreement?
Fuel supply agreement.
Yes.
Did you supply, when I say you, I mean Namcor, is from the effective date, did Namcor supply fuel to Enacon in accordance with that agreement, of course, using those assets?
Yes, I believe so, Your Worship.
You're saying yes, you believe.
Yes, I believe so, because there were subsequent payments that were made after that effective date. In fact, if I may, Your Worship,
Carry on.
This agreement persisted until such time that it was cancelled, but that was way after I had left Namcor and way after these specific directors of Enacon had left Namcor. So by the time that I was there at Namcor, the time that these directors were there, this agreement was in full force in effect. So those assets did belong to Namcor. And whether Namcor utilized them or not, I mean, that's not really the issue. But I believe, as I was told, that they were utilized. Some fuel from Namcor was put in those facilities.
Yeah, that's correct, Mr. Mulunga. Let's move to page 86. You touched on something which is very important, Your Worship. Page 86 to 88. Are you there, Mr. Mulunga?
Yes, you want me to read?
No. I want you to identify that document.
Okay, this is a letter written on the 17th of July 2023. So it's basically a year later, after we had signed the asset purchase agreement. So 1 year later, there was a letter written by Mr. Victor Malima, the Chief Executive Officer of Enacon at that time, to Masashiwana Ndeunyema, who was at that time the acting managing director of Namcor.
That is the time when you're on suspension.
Yes, I was already on suspension. I went on suspension on the 4th of April, 2023. So I had left Namcor by this time.
And then someone was acting.
Somebody was acting.
What does the subject matter of the letter?
Namcor Enecon contractual matters and Enecon's revised debt repayment plan.
Please read the reference.
Reference is made to the above matter and the meeting of 17 July 2023. We wish to confirm that Enecon is committed to resolving the issues arising from the said meeting as follows.
Number one,
Asset purchase agreement. It is noted that there are differences in the interpretation ascribed to the assets. Purchase agreement dated 15 July 2022. As a way forward, Enecon proposes to have a cancellation of the agreement by mutual consent, and Namcor is reimbursed the amount of 53 million as a once-off payment.
wow. And you are being prosecuted for having stolen or making gratification and rewards in the same amount.
Yes.
And someone is making an offer to pay back the full amount to Enecon, not to Namcor. Let's look at what Namcor says about that, because the others, we don't want to go into peripheral issues. Let's focus on the real issues. Let's look at the answer, Your Worship. It's at page 89. Are you there?
I'm there, Your Worship.
I want you to identify the document.
This is a letter dated the 5th of October 2023, authored by Masashiwana Ndeunyema, the acting managing director of the National Petroleum Corporation of Namibia, Namcor.
Yes. So, and addressed to Victor Malima.
Yeah, and addressed to Mr. Victor Malima, Enecon Namibia Pty
And the
Limited.
subject,
Cancellation of asset purchase agreement between Enecon Namibia Pty Limited and Namcor Petroleum Trading and Distribution Pty Limited. Namcor Trading and Enecon's debt.
okay? I want you to look at the relevant portion of that letter. That is, Your Worship, you can start by paragraph 2 of the same letter.
Okay. Namcor Trading's letter of 12 September 2023 was premised on Enecon's proposal to cancel the asset purchase agreement between the parties and Enecon to reimburse a sum of 53,212,000 Namibian dollars as a once-off payment.
Correct. 3,
Namcor Trading accepted Enecon's proposal to cancel the asset purchase agreement, subject to Enecon's reimbursing the amount stated under clause 2 above, and in addition included interest charges for Enecon's payment.
yeah, incredible. So, Enecon, represented by Victor, wrote a letter to a certain Shiwana Ndeunyema, acting managing director of Namcor, proposing a cancellation, and in response, dated the 5 October 2023, the acting managing director of Namcor accepted the cancellation. That is a paragraph 2.
That's correct, Your Worship.
No, paragraph 3.
Paragraph 3, yeah.
Yes. So that is after you have left Namcor.
Yes.
Okay. Carry on with 4.
Enecon's letter dated 21 September 2023 accepted the proposal to cancel the agreement, but they rejected the condition that Enecon shall reimburse Namcor Trading the amount stipulated under clause 2 above and payment of interest in the sum of 7,211,456 Namibian dollars 7 cents.
Yes. And then 5.
We hereby reiterate the fact that the asset purchase agreement between the two parties therefore remains intact, valid, and binding until such time as the condition of reimbursement of the funds stated under clause 2 above is met and the settlement agreement is signed between the parties.
Okay. Yeah. I don't know. You can see there is a problem here. They say they accept cancellation, then they say the agreement remains intact, but that's for argument, Your Worship. And then 6.
Namcor Trading is willing to waive the interest charges. However, the sum set out under clause 2 above shall be payable by Enocon.
I see. So now Namcor Trading is saying it's okay. You don't need to pay the interest by the amount in paragraph 2. If you go back to paragraph 2, this is the same amount where you are being charged for conspiracy, theft by false pretense, and all sorts of allegations, correct?
That's correct, Your Worship.
Okay. And now, 7.
Namcor Trading reserves all its rights as it pertains to the asset purchase agreement and in law.
Yeah, of course, Mr. Mulunga, I remember we said in the event there is a dispute, you remember there is an arbitration clause.
Yes.
Now, as far as you know, I don't want to bother you with all the remaining paragraphs. If, I know you are not a lawyer, but as a managing director of one of the biggest parastatal dealing with the oil products, you would understand. If you cancel a contract, if both parties agrees to cancellation, what must follow? What is the next step? If you don't understand, you can say. Okay.
Yeah, no, I don't understand. Yeah, in terms of?
We will argue, I must place this on record that, Your Worship, once both parties to a contract agree to cancellation, the next step, which is a natural step, is restitution of damages. Whoever received anything from the other party must restore, because you can't keep that performance unless there is a legal basis for that. So, Your Worship, that is the examination chief for the applicant. Unless maybe, hang on. My colleague was trying to remind me about the bail condition, but I remember I've placed it on record, Your Worship.
Yeah.
Please, the court, Your Worship.
Yeah.
Unless there is something you want to add?
Yes, there is something that I want to add. Yeah, obviously, as somebody with 25 years experience in this industry, I understand that the court might not really appreciate how these types of transactions are done. So perhaps if the court can allow me 5 minutes, maybe just to explain actually why asset purchases are done in the industry, and maybe to put this transaction with Enocon and Namcor Trading into context, if you allow me, Your Worship.
Please go ahead.
Okay. So, Your Worship, I mean, selling of large volumes of petroleum products is a very competitive business undertaking. So the various petroleum marketing companies, such as the likes of Engine, Vivo, Puma, Total, and Namcor, and some of the other resellers like Enocon and EcoFuel, whatever, they are in a forever struggle to compete for the limited amount of customers that are available, especially for these large volumes of, that's 500 liters per month and above, 1 million liters, 2 million liters per month and above. So there's very, very tight competition, and sometimes they fight so hard, to snatch even customers from each other. So for large customers like mines, transport companies, municipalities, road construction companies.
Try to go slow because
okay.
His Worship is taking notes.
Okay, sorry, Your Worship. Yeah. Government ministries, for them to give a tender or award a fuel supply agreement to a supplier such as these that I just mentioned, I mean, the supplier needs to make a proposal to such a customer that includes various, variables such as the price, the discount, or rebates, the number of years that they are willing to supply. and also to actually offer to construct fuel dispensing equipment, bulk fuel storage facilities, basically large tanks. That's what bulk fuel storage facilities are, large tanks. To construct those assets at the customer's premises. Because if you're selling fuel to somebody, I mean, you can't sort of drive lorries constantly to the facility. You need to have facilities where you store the facility. That's how you sell it. And the customer then would use the fuel on a daily basis as required. So depending on the numbers of liters that the supplier intends to sell to the customer over a period of time, this would then include an investment into these bulk fuel storage facilities or assets at the customer's premises into where the customer's fuel would be stored. So this is exactly what Enecon did when they entered into a fuel supply agreement with the Ministry of Defense. I think it was in 2016, if I'm not mistaken. And this is what Namcor or any other fuel supplier does. And if I can give you maybe 2 or 3 examples of, this transaction with Enecon, this fuel supply agreement connected to asset purchases, it's not anything unique. It happens all the time. And I just want to maybe give 2 or 3 examples.
Please go ahead. Yeah.
Okay. So in 2010, 2011, thereabout, Namcor won a tender to supply a new uranium mine, a mine called Lange Heinrich, to supply it with a product called heavy fuel oil, HFO. I hope I'm not going too fast, Your Worship.
Okay. Proceed.
So Namcor then had to build storage facilities on the mine to make sure that the mine had enough fuel to operate. Because the mine was very far from the electricity grid, the mine was using this HFO to generate electricity. So it had to have product all the time, constantly, to generate electricity. So those assets, then depending on the terms of the contract, or in fact Namcor then would recoup. I'm speaking under correction, but I think that amount in this example was about 19 million. So Namcor spent 19 million to build those storage facilities. Yes. And of course, they had to recoup that investment over time. And after they have recouped the investment, then they would either give over the facilities to the mine, depending on what the contract was. I can't remember what those final terms are. Or if the recoupment is not done, the Namcor would then on-sell it to the next supplier.
Yes.
Yes. So, in another example, I mean, when I came to Namcor in 2015.
Before you proceed, in the event that Namcor sells it to another supplier, who is the owner?
Then the owner would be that new supplier. Yes.
You were about to give
another example.
Yes.
Another example which is closer to home to this example of Enecon. When I joined Namcor in 2015, I think I lobbied with government for the government to actually talk to the Husab mine. Husab mine was the biggest, or it's still the biggest uranium mine in the country. And one government company called the Pangelo Mining had 10% shares in that mine. So I lobbied with the minister to say, please make sure that, because there was another tender coming out. Engen was supplying the mine at that time, and their tenure, basically, the tender came to an end.
Correct.
Yeah, so I lobbied, and then the mine issued the tender to Namcor. These are large volumes. I think it's probably more than 1 million liters per month or so. So again, speaking under correction. But there were facilities there that were built by Engine.
And then what happened to those facilities?
So, I mean, as industry practice, there was no way that Engine would allow Namcor to come and put their fuel into those facilities, because they built them with their money. So what we had to do is to obviously enter into negotiations with Engine and agree on a price to actually purchase those facilities. And we did that. I think the amount at that time was about 35 million. So we actually had to go to the bank, borrowed money, and pay for those facilities. So the Engine goes out of the equation because they're no longer the supplier. We won the tender, so we supplied the mine with fuel for the tender period.
I wish the investigation officer in Nambao should have spoken with you.
Yes.
You were definitely going to give him
Yes.
a thorough explanation, and he wouldn't be sitting here.
Yeah. So the other example, another smaller example would be Namport, for example. Namport used to be supplied by, I think it was Engine or it was Total. It was actually Total. And because they had issued a tender, and that tender also came to an end. And Total had their storage facilities on the premises of Namport.
Of Namport.
Yes. And again, we won the tender to supply Namport. So again, in that example, we couldn't just come and supply Namport, putting our fuel into those tanks, because they were not ours. So either Total had to remove their tanks and we put our own tanks, or we could go into an arrangement with Total to say, we will buy over your facilities. And that's what we did. So this is industry practice. This was not a unique transaction.
Yeah, thank you, Murunga. Of course, that's what they say, ignorance kills. Yeah. For ignorance, they think that you bought dreams.
Yes.
Please, the court, your worship. That is the examination in chief for the applicant, for the fourth applicant.
We can proceed.
Now, Mr. Murunga, the court gave me leave to cross-examine you, and I am acting on behalf of 3 applicants. You know that.
Yes, I know, Your Worship.
In respect, Your Worship, of applicant number 3, I have no single question. It is in respect of the first and second applicants that I will canvass few issues with you, Mr. Murunga.
Yes.
But just to start with the issue that my colleague canvassed you at the end, as an experienced corporate leader and an executive of many years in the petroleum industry, a dispute of this kind, say arbitration between 2 parties, what would be the appropriate composition of the parties arbitrating? Which experts would you need, assuming, for instance, I'm saying this because between you, that is Namcor Trading, and Enecon, the agreement provided for an arbitration,
Yes.
not a court of law. As far as composition of arbitration, who in the industry or in Namibia would be a better positioned person to understand the industry practices, the laws, and everything for purposes of adjudicating a dispute, like you were explaining now?
The short answer, Your Worship, is a subject matter expert. Somebody who understands, somebody from the industry, somebody that has many years of experience of how these things actually operate.
Now, you have listened to the state asking my client and asking for a title deed in respect of the right, title, and interest being the subject of the asset purchase agreement between Enecon and Namcor Trading. What would you say to such expectation from the state?
No, I mean, these type of assets, you don't have title deeds. That is, I mean, title deeds are for, immovable property like houses and so on. So yeah, I mean, a title deed there would be something that is a bit inappropriate to request.
You gave examples of Namcor Trading establishing its supply center, so to say. I'm using my own language. At Yusab Mine, and you say when you leave, those assets will be yours. And when you came in, if they were asset of somebody else, that will be asset for the other supplier. Did you say that?
Yes, I did.
In relation to previous instances where you took over another supplier's asset, where you provided with title deed?
No, Your Worship. I cannot remember that we have received a title deed. We have received confirmation.
But would a pump require a title deed?
No.
Now, I want to clarify something go to page 51 of the bundle that my colleague refer you to. You have spoken about, I just want to clarify, bulk storage facility. Remember you spoke about that?
Yes, I did, Your Worship.
But in the agreement, can you just read out the full paragraph, the second paragraph at page 52? Can you just, page 52, in the preamble of the agreement, second paragraph, to give meaning to the bulk storage facilities. Yes. Can you read it out?
Whereas Enecon is the owner of certain bulk storage facilities comprising those assets and any and all equipment used by Enecon in conjunction with the operation of said assets set forth in Exhibit B, attached hereto, hereinafter referred to as the assets.
Okay, so in other words, you used, and I counted about 5 times bulk storage facilities owned by Enecon. So were you then referring to the facility comprising of those assets and any and all equipment that were being used by Enecon at those bases?
That is correct, Your Worship.
And are those the assets in respect of which the evaluation was done by your internal department and the outside engineering company?
That's correct, Your Worship.
Are they also the asset in respect of which the financial analyst, the expert, did projections you spoke about this morning as to how Namcor would recover its, would recoup its purchase price of the asset?
That's correct, Your Worship.
And you referred to, it was not that clear. You said, if we maybe can go to those projections, Your Worship, it is in our bundle. The main bundle, I think, is D1, the one that has 286 pages. And for the witness, may I ask that the witness be provided with our second bundle? I'm referring to you can use your defense.
Yeah, maybe you can just, which page is?
Okay, you gave the second. Yes, okay. Go take that small bundle.
Okay, page.
Okay.
Okay.
Just hang on. You go to page. We are using my so to avoid confusion. Yes. I'm just trying to avoid confusion so that we use the same document.
Yeah.
Go to 243 of the small bundle that we gave you. 243 of our bundle.
I'm there, Your Worship.
Now, you spoke about 4 years in your testimony in which Namcor Trading would have recouped or generated the purchase price it paid for the asset. Remember, we spoke about
it's called break even.
who determined that, and where? If you can just show the code.
It was determined by this financial analyst.
Who is the financial analyst just for record purposes?
It's Mr. Sam Hashela, who was working for Namcor from Namcor's finance department.
Okay, and is that an expert in this area in making projections?
Yes,
you know him.
That's his daily job. He does these things on behalf of Namcor Trading.
Okay, and so what was his responsibility when he compiled this project feasibility model?
Well, I mean, his job was to do what we call a discounted cash flow.
Yes.
Which is basically the same as a project feasibility, to actually ascertain whether it is financially feasible to make this investment, whether we are going to make money or not.
Okay. Is that an internal process at Namcor Trading?
Yes, Your Worship.
Did accused number 1 and applicant number 1 and 2, the Elindis, did they have any input in the internal process to determine whether or not Namcor could recover its purchase price if it took over?
No, they didn't, Your Worship.
Did they cooperate with any of your people in terms of this projection?
No, they didn't. All that they submitted was the asset register, and yeah, as required by the agreement.
Okay.
Are you saying no, they did not?
No, I say no, they did not.
Okay. And can you just show for record purposes, because I would want to refer that when I make arguments at the end of the bail application, where can one see the 4-year period that was projected by Ashera?
It's on that same page 3.
Page
3, yeah.
I use the number on the top. So
on
245.
245.
Yes. Where is the?
If you just that, because these have been stapled. Can you see a 4 years there? 1, 2, 3, 4, 5. After the 79%, after the margin of safety, you see there's a number 4 years.
I just want to make sure. Are you dealing with the where it says variable investments or something else?
You know, under the paragraph titled feasibility study results.
Yes, I can see that.
Okay, so just go down.
Yes, I can see the 4 years.
You can see the 4 years. So if you go to the left, it will actually tell you payback period.
Yes, payback. Yes.
Yeah, unfortunately, you might not be able to see it because
of that hole.
Because of the hole, yeah.
Is that okay?
But in my bundle, I mean, it's very clear.
Is that for record?
That's
exactly why I'm taking you there.
Yes, that's a payback period, 4 years.
So, in as far as Namcor, do I then understand from you, as far as Namcor Trading is concerned, it worked on the basis that going forward, within 4 years, the 53 million would have been generated from the operation of Namcor, the relationship.
That's correct.
Okay. And you already said that my client has nothing to do with those projections.
Yes.
Okay. Now, again, and I'm doing it with speed, if you go to page 256 Of
This
my,
one?
yes,
Yes.
256, Your Worship.
I'm there, Your Worship.
That appear to be part of the same feasibility study, is that correct? Or is it something else? 256?
Yeah, it appears as if it's the same.
Look at the document, take your time. And what is the title? Just take your time.
Yeah, no, it's the same document, project feasibility model.
Okay. Now, I just want to, you have stated that my clients have no influence whatsoever or input in the feasibility study except providing you with the asset register.
Yes,
Remember I said that?
I did say that, yes.
Okay. May I invite you to go to page 264? 264, same document. Maybe for context, at the time, look, Mr. Murunga, at the time, your institution wanted to offer my clients, to approach my client. The remaining period of ENECON and Ministry of Defense agreement was about how many years?
9 years.
9 years.
Yes, Your Worship.
So do I then understand you to mean that you were working to exploit the right interest and title for the remaining period?
That's correct, for the 9 years. However, the supply, the fuel supply agreement was for 10 years. Well, yeah.
Yes, that the March 2022. That's not the March 2022
yes.
supply agreement with ENECON. Is that what we are talking about?
Yes.
Yes,
that
fine.
was 10 years.
But for you to be the strategic primary supplier, you worked on how many years? What was the remaining period for ENECON?
9 years.
Okay. So in other words, your benefit, your interest, your investment was for that remaining period.
Yeah, it was, yeah.
And on your
For the assets, yes.
Yes,
That's
yes.
what we worked on, yes.
of which 9 periods you have projected that the 53 million you purchased, you used as a purchase price,
Yes.
will be recovered in the first 4 years.
That's correct, Your Worship.
What were your projection? What would you, in respect of the remaining 5 years? So your own projection tells you within 4 years, the 53 million paid to ENECON would have been recovered, and the 5 years.
Actually, we work on what we call a net present value.
Uh-huh.
The net present value of that investment over a 10-year period was more than 22 million. That was the net present value. But I won't be able to tell you that, yes, for the 5 years. In fact, I probably would be able to tell you on this. I saw some of this projection where it's actually showing, on page 256.
256.
256, if you go 258.
258.
So you see where it says 10 years there.
Yes.
There's a corresponding figure of 67 million. So
67.
67
Yes,
million,
at the bottom.
632.
Yes. 121. On the right, it's written 121.
120.
Yes, 120. Right?
Yeah. So after, the way I understand this is, after you've paid back, or after the payback period, which is
4 years.
4 years, where you then, in 10 years' time, then this is the amount that you would make additional to the
To
the
your
payback.
recovery,
Yes,
in terms of the purchase
yes,
price.
Yes.
Now, if you did not approach, and I'm saying you, Namcor Trading, if you did not approach my client, this would have been an asset in the hands of Enecon. Is that not the case?
That's the case, that's correct.
Did my client ever do anything that is inappropriate commercially or legally for you to approach it and offer to buy its lucrative asset in its hands? In other words, in Enecon's hands, represented by the two clients of mine. Did they involve themselves in anything inappropriate commercially or legally to entice you to approach them to get your hands on this lucrative asset in their hands?
No, absolutely not. As you say, Your Worship, we were the ones that approached them because we saw a business opportunity to make money for Namcor Trading and Distribution.
Go to page 271. Is the code 271?
Yes, I'm there, Your Worship.
That is a memo that you dealt with and Mr. Elindi also dealt with.
Yes.
Now, I'm asking you this question in context of fraud charges and corruption charges against my client and conspiracy, that week, 1 week count.
Yes.
But I want to deal with you from the perspective that you were representing the victim of fraud, apparently. You were the one representing Namcor Trading, were you not?
That's correct, Your Worship.
And my clients are being accused of making misrepresentation to Namcor Trading, is that correct?
That's correct.
Is it not common cause that Namcor Trading is a corporate entity?
Yes, it is indeed a corporate entity.
It doesn't speak.
No,
It doesn't communicate.
no,
Somebody does on its behalf.
that's correct, Your Worship.
In liaison with my client's company, Enecon, were you not the one that concluded the agreement on behalf of Namcor Trading?
Yes, I was, Your Worship.
Okay. Now, you have read count 49 against my client, one of my clients, the same in respect of the other one. Fraud count.
Yes, I've read it.
Have you heard about the allegation that my client made misrepresentation and pretended to Namcor? Have you heard that?
I have indeed, Your Worship.
So, based on what I asked you, when the state said Namcor, it's actually you. You represented Namcor.
Yes, I represent the Namcor, yes.
My clients, in their capacity as directors of Enecon, liaised with you and concluded an agreement with you as the face of Namcor.
That's correct, Your Worship.
Did they pretend and make misrepresentation to you as Namcor?
No, they didn't.
Did you ever accuse them of fraud?
Never.
Could they have committed fraud without making representation to you? Could they ever commit fraud, seeing that you are the one representing Namcor in the conclusion of the agreement? Is it a possibility to commit fraud in relation to that agreement without making those misrepresentations to you?
No, that's an impossibility.
But, sir, can I ask you, if they did misrepresentation to you, does it make sense to be enjoying the accused dog with them? Can't you be the complainant? Does it make sense for the police and ACC to arrest a person who committed fraud and the victim? Does it make sense?
No, it doesn't make sense. I should have actually then be free while they are in custody, if that was the case.
But are you prepared, that version that on my question, if this matter goes to trial, I hope it must not collapse before that, but if it goes to trial, will you be prepared to repeat and testify under oath as you do in that my client did not misrepresent any fact to you?
Yes, I will be prepared to do that because that is the truth.
Okay. Now I want you to, through you, because I was asking my client on the basis that they were alleged to be the fraudster, the one that committed fraud. But I want to ask you, as a representative of Namcor, but unfortunately, you are also an accused person now. Now, look at page 271, Your Worship. You see background.
Yes, Your Worship.
Can you just read that paragraph? And I want to ask some question because I want to start cutting the state case into pieces through you.
Okay, I shall do so.
Yes? Can you read that paragraph?
Eneco Namibia is a Namcor customer since November 2021. Eneco Namibia currently has an agreement with Namibia Defence Force to supply them with petroleum products till 2031. They have been supplying the Ministry of Defense with petroleum products since 2014, and part of the agreement was to ensure relevant infrastructures are in place to fulfill their obligation towards their contract.
Okay, just one question there. The relevant infrastructures is what? What is the relevant infrastructure through which they fulfill their obligations towards the Ministry of Defense?
It is these big bulk fuel storage facilities.
Those that
The same facilities, the same facilities that we obviously purchase from them, same facilities they use to supply the Ministry of Defense with petroleum products, the same facilities that they bought themselves.
There appear to be a confusion. Somebody say it's a dream. But without those facilities, could one fulfill obligations towards Ministry of Defense?
No, you can't, because you need the facilities to where to store in the fuel that will be used by the Ministry of Defense at the various bases.
And when you use those facilities to supply, how do you make business? How do you make money? Where does the money come from?
Well, you store the fuel that you are selling to the Ministry of Defense into those facilities.
Yes.
And then the Ministry of Defense fills up the vehicles from those tanks,
Yes.
and then obviously they pay you then, or they pay whoever supplied them the fuel.
Okay, then correct me if I'm wrong. If that is the case, then that infrastructure that enable you to fulfill this obligation so that you are paid for the supply of petroleum products,
Yes.
correct me if I'm wrong, then it is an imported asset in the supplier's hands for purposes of conducting its business.
That's correct. You've hit it spot on. That's correct. Because without that, you can't supply.
And if taking that together with your testimony today on the practice, or on the industry practice, it's an asset where you can put a value.
Oh yes. I just demonstrated it earlier.
But was it not? Why, if my client came and say, we don't want your 53 million worth, we want $1 billion for that asset, would have it been an offense? If my client insisted, we don't want this part, we want to sell you $1 billion, is it an offense from the owner of the asset, if approached by somebody, to put a price on asset it has?
No.
But in this case, who approached who?
Namcor approached Eneco.
You actually, you're representing, I'm not saying you did anything wrong.
Yeah.
You approached my client.
Me as the managing director of Namcor Trading and Distribution made an offer to Eneco to purchase those facilities as per the fuel supply agreement that was already negotiated and signed in March 2022.
But lest we forget, but there was a build-up including internal processes. Is that not correct?
That's correct. That's the process that is normally followed. That's the process that we follow.
Okay, can we then move to page 272 so that I want to finish with speed, please, but this is important for my client. Now, can you read out the first paragraph at page 272?
Additionally, Namcor would like to become the preferred supplier to the Ministry of Defense in the long run, and through acquiring these assets, It will put Namcor in a favorable position for future business relations with the Ministry of Defense.
Now, when I read this, correct me if I'm wrong, this is an internal policy, strategic statement. Strategic and policy because it says Namcor would like to become the preferred supplier to Ministry of Defense in the long run, and through acquiring this asset, it will put Namcor in a favorable position for future business relationship with the Ministry of Defense. Am I wrong to say, Namcor, internally, you crafted and adopted a strategic policy to take over my client's assets?
Yes, it was
without instigation from my client.
It was a strategic move from Namcor Trading and Distribution to say that eventually that's where we want to go. We want to be the one supplying the Ministry of Defense directly, but obviously you cannot do that if you don't have assets to supply them into. So therefore, the strategic imperative was to buy these assets from Enecon so that one day, obviously, when the contract expires, whatever, or if their relationship with the Ministry of Defense comes to an end, then we would then come in and supply the Ministry of Defense directly.
That's exactly what you said. I think your policy was, in fact, your eyes were actually beyond more than 10 years. In other words, you buy these assets so that in future, for future business relationship, that would have placed you in a position to be the primary supplier.
Yes, because once we buy those assets, we could actually then, according to the agreement, preclude any other supplier to supply their products into those tanks, into those facilities, because then the facilities would become ours, or unless it's Enecon.
Okay, and lastly, I see from the next paragraph that it says that Namcor has made provision for this takeover in the current financial year budget. Now, this was in, what is the end of your financial year? Namcor Trading, if you can.
End of March, Your Worship.
So then, it appears by March, long before the agreement was signed, the purchase agreement in July, internally, Namcor actually had a budget without offering to my client.
Yes.
Already had a budget to take my client out of that lucrative business, internally without instigation, without a criminal activity on the part of my client.
Well, we had a budget for asset acquisition and we had a budget for business development.
And was this budget ever withdrawn?
No, it was not withdrawn, Your Worship.
And we know now that there was there were two valuations, one at 55 million, one at 53 million. Is that correct?
That's correct, Your Worship.
Now, there is a civil case in the High Court, in the next building. Are you aware or you are not aware?
I am aware of that case.
Now, you have heard, I don't want to waste time, you have heard me going through with accused number 5, Peter Elindi, the particulars of claim. Were you listening when I was doing that?
Yes, I was listening, Your Worship.
Now, in those particulars of claim, one of the main complaints by Namcor, the bigger company, and Namcor Trading is that allegedly the employees, including yourself and some other people, worked with my client in relation to a sham valuation. Were you following?
I was following, yes.
In this court, let me just ask, in the charges you are facing and faced by my client, is there any complaint by the state in relation to a sham valuation in the criminal court?
No, there isn't.
But in the commercial court, in our neighbors at the High Court, there is.
Yes.
Do you know why in the commercial court the dispute or the complaint by whoever went to that court is different from the one the state is relying on. Do you know why?
No, I don't know why, Your Worship.
Those particulars of claim do not suggest. You go to page, Your Worship, in the bundle that we are relying on, those particulars of claim are at page 17 to 30. Second amended particulars of claim.
Okay, I don't have. Bundle.
If you can, yes.
Yeah, I'm there, Your Worship.
You see that?
Yes.
And if you go to, and I want to take you to the discounted projections, DCF. Yes, go to page 26, Your Worship, page 26. Are you there?
Yes, I'm there, Your Worship.
Now, you see at the bottom 31.3. Can you just read out that sentence?
So you said page 27?
26.
26.
Yes.
Okay.
31.
Yeah, the discounted cash flow DCF methodology used by Mr. Sam Hashela, the financial analyst, to forecast the financial performance and sensitivity analysis of the proposed asset acquisition was not appropriate and was necessarily a sham because there was no contract between MOD and second plaintiff for second plaintiff to supply petroleum products to MOD.
Okay, but let's go back to Sam Hashela.
Yes.
Do you know him very well?
Yeah, I know him.
What qualification does he have, if you know?
I think he has a master's degree in finance, if I'm not mistaken.
But is he an expert recruited by Namcor?
Yes. Yes, Your Worship.
How long have you worked with him?
Oh, I mean, I found him at Namcor in 2015, so say 8 years.
Did you doubt as the MD? Did you doubt his work?
No, because, I mean, this was his daily work. I mean, he didn't only work on this DCF, he's been working on some other DCFs as well. This is his daily job, his job description.
But let's assume he did a bad job.
Mm-hmm.
Do you have any evidence of my client's involvement to make him do a bad job?
No, I don't.
Will that even make sense?
It doesn't make sense to me at all. It's not logical.
Okay, and now let's end with the charges against my client that mention your name.
Yes.
If the witness can be given our bundle that have the charges and I think it's D2. I can hand up one. No, that will confuse him. Yeah, can you give this? I just want to ask you, sir, I want to understand this. This afternoon, I understand you were, my colleague, your legal practitioner, took you through count number 2, that is fraud.
Yes, he did.
I don't think it's in that, is it in that? I think the first page is missing there.
Yeah, the first page is missing.
Yeah, go to your bundle, get it. Now, I want to kill one count against my client through you. Are you at count 2 against him?
Yes, I am.
And you explained eloquently today, I was listening very carefully, how you denied the charge that you did not have authority. Remember you explained today?
Yes.
Because is it my client's business to know whether or not you have obtained authority?
No, I mean, I'm sure they assume that I have authority if I enter into a contract with them.
Is it the policy you refer to and the derogation of authorities documents? To whom are they applicable?
The Namcor employees.
Is it applicable to business people you are liaising with on behalf of Namcor?
No.
Is it even their business when you speak to them over the phone to lecture them on your derogation of authority?
No.
But didn't you tell my client through the agreement that says you are jury authorized, didn't you tell my client you are authorized?
Yes, I did.
So, do you understand the state taking on my clients in a criminal court in relation to your lack of authority? Do you understand where the problem is on the part of my client?
Well, it sounds ludicrous to me, to be honest, worship. That's the only word I can use.
You are the person that worked with my client. If this matter goes to trial, would that be your version that they must assume that you have the authority?
Yes.
If you can go to now count 43. No. At page 14, count 34, Your Worship. Now, maybe, what is a service station? You have been in the industry for 25 years. What is a service station?
Yeah, a service station is basically a place where you go and fuel up your car with diesel or petrol. It's a station that is normally branded by one of the well-known petroleum marketing companies, whether it's Engine or Puma or Namcor. Those are traditionally what are referred to as service stations.
Okay. Now, let's give a practical example. You said you are from Omtere.
That's
Is
correct.
that originally?
Originally, yes.
And I see there is a road now, tired road going there,
That's
being
correct.
built.
That's correct, Your Worship.
Just in the industry, assuming you have a plot, customary communal land, you have all the certificates, and Total or Enecon, and somebody comes, put up tanks and pumps for purposes to conduct business.
Yes.
Who would own the title, the right, and interest in those pumps? And
Before you respond, you must make
If, let's use the example of Total. If Total are the ones that construct or erect those tanks, pumps, and related infrastructure, they would enjoy rights, title, and use to those facilities.
And if you in the village with the communal land, you have given them 3 years and they want to sell to somebody the remaining 2,
Yes.
is it possible to sell that right, title, and interest as an asset in the remaining period?
Yeah, that's possible.
Now, do you understand now? Look at count 34, fraud. The state says my clients committed fraud because they made misrepresentation to you, because you said you were the one representing Namcor, that you were selling 9/7, they were selling 9/7 station. First of all, did they ever tell you they are selling 9/7 station?
Never.
were my client in a position to give you the right to be the primary supplier, doesn't matter whether directly or through them, in relation to the Ministry of Defense, was that possible for them to sign an agreement and give you the right to be the primary and exclusive supplier to MOD, those many, many thousands of liters?
Well, in fact, that's what they did. That's what we did together in the fuel supply agreement. They gave us the exclusive rights to supply to them so that they can't go and be supplied by somebody else. We would be the sole and exclusive suppliers to them so that they in turn supply to the Ministry of Defense, because they are resellers. They are not at our level, but we sell to them and then they sell to the Ministry of Defense.
Maybe somebody is thinking, if you buy this right, title, and interest, and you continue to supply to them, they supply physically to defense. Maybe you are not doing business. Were you not doing business?
No, of course we were doing business. We were selling.
Were you not making money?
We were making money.
Were there no profit margins?
Yes, there was.
And if you move to page 15, oh, sorry, I think it's in your charges where I saw you allegation that my client conspired with you, amongst others. I think it's in your bundle. Let's go to your charges in your bundle. Listed for 7. I just want to complete, make sure. Okay, let me ask you, do you know, only if you know, do you know what is to conspire?
I believe I do, yes.
Yeah, yes, just your understanding. I will.
Conspire
If
is...
somebody said you conspired with A and D to do whatever, what is your understanding?
Yes, my understanding is that you actually sit down and plan with somebody to perform a certain act, which in most cases is probably illegal.
Okay. My client's instructions are that they are not aware of any criminal offense you committed. They are not aware. And if you did, they were not part of it.
Okay.
Do you have any comment? They are not aware of any criminal act you committed, and if you did, they were not part of it. What is your comment?
Well, I mean, I believe they are correct. There is no reason for me to think that they think otherwise.
Now, your letter of the 8th of July 2022 is the trigger legal step for my client to accept to enter into the agreement. Is that correct?
That's correct.
That offer.
Yes.
Without that offer, would there have been this contract? This 53 million. If Namcor did not offer, I'm not saying there is anything wrong.
Yeah, no. They wouldn't have been.
If my client did not receive an offer from Namcor Trading, would there have been an asset purchase agreement?
No, we would have not complied with Article 4.5.1 of the fuel supply agreement. That's all that we would not have then done.
Yeah, but it's up to you whether nobody then forces anybody to ultimately complete, because it's an independent agreement on its own.
That's correct.
If you did not make an offer, the fuel supply agreement would have ended on its own.
Yes, it would have.
Am I correct to say that?
It would have died a natural death, because you can't you can't supply to somebody exclusively if you don't own the tanks where you are supplying them to. Because if they decided that they were going to be supplied by many different people, then we wouldn't have those exclusive rights, and therefore we couldn't insist that we are going to put our fuel in there just as.
But what did you contemplate? If they, my clients through Enecon breach the contract, including failure to pay, what did you agree? What did you contemplate? What should happen? If any one of the two parties breach the agreement?
Yeah, well, there were remedies. I just have to go back to
page 51. The agreement is at page 51.
I mean, either party had legal recourse to the other.
You refer to page 58. Go to page 58.
Your Worship, I have to object to that line of questioning, because if he knows the agreement, he must go to the agreement himself, because counsel is actually leading him to that specific. This is not evidence in chief, it's cross-examination.
No. Okay, can I respond? It's common cause already. The agreement is not in dispute. I am asking in respect of a particular document identified already to a witness. I can never waste time to say, was there a purchase agreement so that the witness start repeating. I am referring to him, to the agreement, and say, you already testified about this, then I will ask my question. May I proceed, Your Worship?
Also consider that the documents are before court,
Yes.
and directing the client to the page is just simply also saving time.
As a court, please. Are you at page 58?
Yes, I am, Your Worship.
And you see close, you already read that is arbitration.
That's correct.
And that arbitration is between who?
Between
It's
the
for
two
purposes of what?
It's between the two parties to resolve any differences of opinion, or any differences, or any breaches, whatever it is.
Okay, but then what I'm interested, can you just read out at page 59, 8.5, my colleague, your legal practitioner didn't have you read that, but on behalf of my client, that is important in my cross-examination. Can you read it for the record?
Yes. The arbitrator will be entitled to make such award, including an award for specific performance.
Just end there. What is specific performance? In other words, when you entered into an agreement, you said the arbitrator for the dispute could make specific performance order. What is that? Award. What is that?
Could award for a specific performance for something specific to be ordered to be carried out by whatever party.
By one of the parties.
By one of the parties, yes.
Could that include if you didn't pay an order not to pay, or that is something else?
No, that is included in this.
Okay. Then can you go on?
An interdict, damages.
Yes, just ended damages.
Yes.
Let's assume it was correct if my client impeded you or obstructed you from enjoying the benefit of the asset.
Yes.
You agreed on damages. What, in that context, what did you entail? What did you contemplate? Why should there be damages?
Well, if we are, for example, impeded from making use of the facilities to generate economic value out of them, we would then claim for damages specific to...
Which court do you go to? Is it criminal court, or is it arbitration, commercial court, or criminal court?
Well, go first to arbitration, and if arbitration doesn't work, then you go to a civil court.
Did you ever contemplate that you find yourself in a dispute in relation to the agreement, as you ending up not as a witness but as an accused together with my client?
Not in a million years.
And account of profit, what is that? An order in relation to account of profit.
Yeah, account of profits. I'm sure this is dealing with, obviously the profits that one can generate.
one would have generated.
Yes.
Okay, now I want to end with this. Did you receive any gratification from any of my clients?
Absolutely not, Your Worship.
Did you receive any reward for having done your work in relation to this matter representing Namcor trading
Absolutely
from
not.
my client?
Absolutely not.
Would there have been any reason for my client to give you a reward?
No, because this is a straightforward transaction. Why would somebody in their right mind pay a reward for a transaction that was clearly valid and, went through the process? It wasn't just a matter of me as a managing director of Namcor Trading waking up and formulating an agreement myself, putting in all the clauses and signing it with. That's not how things work.
Okay, and you have been at Namcor since 2015, you said.
That's correct, Your Worship.
We must just be frank. Even assuming this transaction ended up a failure, in other words, for one or other reason it failed, it
Yes.
didn't work out as you contemplated. Is this the first ever transaction that there were failure in terms of payment or product or whatever? Is this the first commercial transaction?
Your Worship, if you operate a business or in a business arena, you take risks, you win sometimes, most of the times you win, but there are some cases where you lose. There's no business arrangement where you just win 100% of the time. There is no company, even in Namibia, where all their clients pay.
Okay.
There are always clients that don't pay. And this is also not the first time in Namcor's history where a client has failed to pay and ended up being liquidated or we went after them. These things do happen. And you cannot, because a client now fails to pay, now you hold the managing director of that institution responsible for that in a criminal court. If this is how we're going to proceed, how will people want to work for public entities?
But for what? I'm representing people who were not working for. You are saying that is shocking. But what about an outsider who then does business with Namcor?
It's even more shocking because the question is, who would want to do the business with Namcor if that is how Namcor operates or takes on their previous clients, take them to criminal court?
As the court pleases, that is my cross-examination.
No, we won't be long, Your Worship. So, Mr. Mulunga, he said.
You think won't be long?
No, we won't be long.
How long?
Probably 10 minutes, Your Worship, but we'll within the time we have available to finalize. Mr. Mulunga, you can hear that the time is ticking, so maybe you should be fast.
Yes.
But take your time.
Oh, okay.
Yes, once time I'm going to.
Oh, okay. That's very generous, Your Worship. Thank you so much. Mr. Mulunga, it is said that Namcor bought trees, and I heard you in this court to be denouncing that statement. Is that correct?
That's correct, Your Worship.
Okay, so, Mr. Mulunga, would you then say that the fuel supply agreement was the precursor to the transaction that eventually came, or that has brought us to this court?
That's correct, Your Worship.
And you are referring us to clause 4.5.1.
That's correct, Your Worship.
Now, let's ask this question. Did Namcor buy 9 service stations?
No, Your Worship.
Now, Mr. Mulunga, would you then agree, and yes, you have already agreed that the fuel supply agreement was the precursor, would you then agree if I make the following statement. I'd like you to go to page 217 of your bundle, Mr. Bangwago's bundle motion.
I'm there, Your Worship.
Do you agree that this assessment conducted by a certain Mr. Shifeni was also a vital aspect to the transaction?
Oh yes, it was very, very key. Because he was our executive for engineering and technical services, so his input was very crucial.
You recall that in the civil proceedings, there was a song and dance made about the fact that he's not a registered civil engineer. Do you know anything about that?
Yeah, I mean, yeah, I don't remember him being registered, but that has nothing to do with somebody who can, make a valuation for assets.
Okay. Did you at any point question the validity, or rather the prudence of this internal memo?
No. In fact, Your Worship, I mean, again, Master Shefeni is our executive for engineering and technical services. He's the one that carry out these kind of investigations all the time. He didn't only do it for this transaction, but when we build service stations or when we, build other assets, he is the one that carries out the evaluations.
Would you then say that this would happen during the ordinary course and scope of his employment?
That's correct.
224. You agree that that is the project feasibility model that was presented?
That's correct, Your Worship.
You said that it was prepared by a certain Mr.
Sam Hashela.
Ashela.
Yes.
Did you have any reason to cast this assessment with doubt?
No.
You also confirmed that Mr. Ashela was an expert in that field, correct?
Yes, he's a financial analyst.
So
Yes.
also you were telling us that he had done previous others of the same nature.
Again, in the normal course of his business, this is the type of work that he would do for Namcor trading and distribution.
So during the normal course and scope of his employment?
That's
business?
correct. That's correct.
Okay. Employment?
Of his employment, yes.
Okay. Now, and I'd like you to go to page 65. That's an internal memorandum. And you note that it's an internal memorandum from Olivia Dunaski, accused number 4, to you as the managing director.
That's correct, Your Worship.
Now, you, of course, during the course of proceedings today, you've also read part of those contents into the record.
Yes, I did.
Did you have any reason to cast this document with any suspicion or doubt?
No, not at all.
Okay. Why were you then comfortable in approving it?
Because, obviously, it didn't just come from one person. It was obviously ordered by Olivia Dunaski, it was supported by Davis Mapos. So all these people obviously would have had insight and gone through all these documents before it came to me. So that obviously gave me more confidence that, my staff members actually went through this, made sure this is something legitimate that Namcor should go into, and they presented to me as a managing director, and obviously I approved it after having read through it.
So, the three documents I covered with you, previously touched on it, but I believe you only touched on one aspect. Would you, if anyone were to say that these were simply shams, it was a misrepresentation, what would you make of such a statement?
It's because I don't see the basis of why one would say something is a sham. If it's something that obviously, if you don't understand the industry, or you haven't worked for Namcor, or maybe you are just a board that maybe perhaps don't really understand the industry, you might end up maybe coming to a conclusion that it's a shame. But there is no basis that it was a sham.
And just as concluding remarks, you agreed that this transaction was in fact to the benefit of Namcor and it would be profitable.
Yes, yes. That is what convinced me to sign this agreement, because just to make also a final and parting statement, that when I got to Namcor, the revenue of Namcor was around 610 million or so per year.
Now, just in conclusion, or are you still?
Yeah, I'm still busy. Yeah.
Okay, yeah.
And by the time that I left, the revenue of Namcor was 7.4 billion. And you do that with this kind of innovative transactions, where you go after businesses, after deals. Yes.
Could you then ascribe the term dreams are valid to this transaction?
If I understand you correct.
Yes. I mean, given what you are saying, I mean, it's profitable, it comes from
Yes.
the process.
Yes.
So it's not just a dream you bought, but
No.
it's actually a valid dream that you had.
Exactly. And unfortunately, Your Worship, unfortunately, the directors of Enocon that I signed this transaction with left on the 23rd of February 2023. And I went on suspension from Namcor over something that was proven not to be the case, be that as it may. I left Namcor on the 4th of April 2023. Unfortunately, what happened after that cannot be ascribed to me, to those directors.
That's the association. That's what
We are going to implement okay. Yes, we are going to implement a role.
Please go to your worship.
Your Worship, I just want to inform the court that out of respect and courtesy, that tomorrow I'm in the Supreme Court and one of my junior will be in court, but once I'm done in the Supreme Court, I will join proceedings.
Also, maybe just for the record, last week I indicated that I had another bill application in Mongondara District. I have communicated with the colleagues yesterday, and we have agreed to have that matter proceed tomorrow in the afternoon at 14 o'clock. But also it depends if they confirm in the morning that they are available, then we will proceed until 1800 hours. However, if they are unable to confirm, then we are going to proceed as like last week.
Mr. Court.
Your Worship, may I request that we start at 10 o'clock, because at 9 o'clock I'm before Leadership Justice Prince Row for a short application. By 10 o'clock I should be done, Your Worship. Please, the court, Your Worship. Unfortunately, it will be very unusual for me to ask someone to stand in for me, because I have to make sure that when my client is being cross-examined by the state or by anyone, I'm making notes for purpose of re-examination.
Your Worship, in fact, we would appreciate if we start at 10. Yes.
Then by agreement, the matter is rolled to tomorrow to proceed at 10.
Please, the court, Your Worship.
The court
Where is your record? This one.
Keep
it.
Yeah.
Keep it.